My name is Todd Sivia, and I'm with Sivia Law. We help people through life's transitions. And today we're going to be talking about the 7 misconceptions about wills. The first one, filling out your will online versus utilizing an attorney. A lot of times people will go to like LegalZoom or some forum online, and a lot of times those forms are just forms. They're really not tailor-made to your system or to what you're looking for. And it is important to draft something that benefits or fits you and not the form. So not all online platforms are going to ask the right questions and that you're going to need to answer because not every situation is equal. And systems like LegalZoom and others are not going to ask the right questions. Misconception 2. A will from one state is not legal in another state. And this is critical with regards to drafting. If you draft and you have it signed in the appropriate way, it would be legal in most states. However, you need to make sure that you have specific language within your will to ensure that you can travel from state to state. Misconception 3. A will avoids probate. This is probably the biggest misconception out of them all. A will truly does not avoid probate. A will actually sets out the parameters of everything that you're going to do, but a will is determined and deemed to be admitted by a probate court. There are certain requirements for probate, and it varies from state to state, but most states have some kind of threshold. For example, do you own real estate? Do you have over $65,000 in assets? And these are typical parameters that if you have below $65,000 in value, or you have less than, or you don't have real estate, then you may avoid probate. But in most states, probate is going to be required, even with a will. And your will be deemed to be admitted by a court. Having a will is better than having no will, but there are other ways to avoid probate. Misconception 4. Your will and your assets remain private. Unfortunately, with a will, it is just the opposite. As soon as you have a will, you must file everything with the court system and publish your will. So everything in your will becomes open to the public, and all your assets become open to the public as well. So having a will does not keep things private. Misconception 5. A will helps avoid taxes. Truly, most taxes in this day and age will be avoided unless you have assets over $11 million, or in the state of Illinois, $4 million. So if you have more assets than that, typically you're going to avoid most taxes. Misconception 6. When you set up a living trust, you lose control of your assets. Living trusts are a form of estate planning. Typically, that will keep things private and things of that sort. But a living trust does not, you do not lose control of your assets. You actually gain control and are able to control your assets. The trust is now the owner and you are now the trustee. It just is a term of art or term of legal art that allows the trust to take place. Misconception 7. I can put off my will until I'm older. Unfortunately, I know too many circumstances of individuals that have died at an early age. How old is old? Typically, at the age of 18, so as early as age 18, you should be looking at having a will. There is no set parameters for your estate plan. Now, this plan will change over time. As soon as you become older, you start owning real estate, you start owning property, you start buying cars, you start having kids. There's a lot of things that go into that will impact your estate. And it is important for you to get your estate taken care of as soon as possible. But we don't want you to delay having an estate plan because we don't know what our expiration date is. Thank you. For more information, click the link below.